All right. Good morning, everyone. Thank you for being here on such a gloomy, smoky, cloudy day. We're just going to jump right into it. I know that we like to get to the important stuff. No one wants to hear anything from me. So we have a couple of really special guests with us today we're excited about. Renee Paulsen will be speaking with us first. Renee has worked for the state for almost 9 years, all with the commission. She started as a licensing specialist in 2014, moved to a background manager, then to the investigator position, and most recently, she's serving as an education director and executive officer of the commission. Before being employed with the state, Renee was a finance manager for a private mental health practice. She has a 2-year associate's degree, along with obtaining her certified public management from Drake University. She lives in Altoona. She's a recent empty nester with 2 young adult kids, 1 grandson, and she's on baby watch for a granddaughter any day now. So if she has to leave, that's why she's bailing. She's not mad at us. She's just going to take off. So Renee, go ahead.
Hi, everyone. Well, first I was going to introduce myself, but I think Krista basically did that for me. So thank you. The other thing I'll do is just introduce my staff. They're not here, but basically we have Chris Conway. If you haven't had the pleasure of meeting her, she's our new licensing specialist. She's great. She very helpful. So please reach out to her with any questions. And then Danielle Barque moved into our background manager position. She is doing all the background checks and E&O insurance audits. Ashley Thompson took over as investigator when I took over as education director. And now I'm in the education director role along with the executive officer role. So, and then we have Colleen Goddard. Most of you probably know Colleen. She is our trust account auditor. And obviously reach out to her with any trust account questions ever. She's very helpful, very knowledgeable. And then I'll just jump into it. With the state, we have quite a few changes going on right now. We have realignment. So the governor put into effect a realignment that takes place on July 1st. So the Professional Licensing Bureau is not going to be any longer as of Friday or Monday, I guess. We will be all underneath DIAL. So it's Department of Inspections and Appeals and Licensing. So we all are branched under that. And then our whole team is being split up. So we are all going under different divisions. I'm under the board support division. Danielle is with me. And then licensing, Lori Schraderbacher will still be overseeing all of the licensing, which will take Danielle or Chris with her, and then Colleen and Ashley are going under the investigative division. I think we'll all still work together. We're all moving to Hoover eventually, so we'll all still kind of be together, but we all have different supervisors. So I don't even know how any of it's going to work, but we'll soon find out, I guess. And then we have the other thing with the state going on, what we call the Executive Order 10, which is rule changes. So the governor has put into place all the rules need to be updated. And basically what she's wanting is less restrictive language and easier to read. So I don't even know how to explain what I'm doing, but we are basically taking out all of this restrictive language. And it's not necessarily because our first reaction was, if we take out restrictive language, what's the point of rules? But it still is all going to be pretty much the same. It's just much easier to read. So actually, after I got into it, I actually do believe this is a good thing that's happening. It's just, unfortunately, it's happening very fast. So I only have a few months to get all the rules together. September 1st, I have 21 chapters due. So that has been a major task that we've all been working on. But that's about it that's going on within the state. And then Amanda asked me to talk about limited service brokerages, or what I call flat fee brokerages. It's hard for me to get too involved in discussion with that because for us, licensee is a licensee. So whether or not they belong to the MLS or not, that is not something that we really get into. But what I can say is do not I repeat, do not submit a addendum or a purchase agreement to your sellers or buyers to get paid commission. I've seen probably a dozen in the last few months. I have issued discipline because that addendum is being presented to clients and the commission is not okay with that. So if that happens and a complaint is submitted, then basically you're going to receive civil penalty and possible education. So that is one thing that I can speak about is if you want to get paid, go directly to that broker. You probably won't get paid, but that is your option there. So that's about all I have to say on that, unless there's any questions.
Yeah. Do we have any questions from the audience or the panelists here today?
And you can type everything in the Q&A for anybody that's on the webinar. So I see a hand up right now on the webinar. Mark Signs. I don't know if Amanda, you can promote him to ask.
Here. He's got it. There you go.
Go ahead, Mark, you're muted, and then
Can you hear me?
yes.
Okay. Just a question, I guess, Renee, we actually just saw recently, or heard of recently, one of the companies is now specifically has a form and specifically saying you have to negotiate your price as a buyer's agent directly with the seller. And they have a form for that.
Don't present that form to the sellers.
Okay. So I'll try to get a copy of that form.
Yeah, you can email it over to me.
And share it with you. Yeah.
Okay.
Because that was just a whole new level of something that we saw recently. So
Yeah, any type of form being presented for you to be paid a commission to the seller or the buyer, and there's a complaint submitted, I promise you there'll be discipline.
yeah.
I've never 100% of the time I have seen the commission find probable cause in that situation.
Okay. And so is the company that's suggesting that or doing that, will they be notified to stop doing that, or?
If you want to give me a call, we can discuss it and I can reach out to them, and maybe go through it with them to not be presenting that, just to avoid any type of complaint or discipline for them. I'm more than happy to reach out to them.
Okay, I'll touch base with you later then.
Okay,
Thank you.
that sounds good. Yep.
Okay, Renee, we have a question typed into the chat here. Can we enter into an agreement for service with our buyer clients and accept a fee?
You can negotiate with your buyer if they're willing to pay you.
Any further questions for Renee? No? All right, seeing none. Renee, thank you so much for your time, and thank you for weathering all the changes and having a great attitude about it. And
I have a couple other things I just wanted to mention that area for questions, but I have a couple of other areas I was going to touch bases if you still have the time. Otherwise,
yeah, absolutely.
Okay. I wanted to touch bases on our complaint and discipline log. And I know I've probably hit some people out there with some really old discipline. So when I took over in December, we had a backlog of about 125 discipline cases, and they dated back to all the way to 2013. So you can imagine hitting somebody with discipline even from 2018. It's not been a pretty battle, I guess, along the way. But I am pretty much caught up. So I'm down to about 40 cases, which we've reached out to the majority of everybody. There's no more basically slap in the face and, they thought these cases went away. Well, they didn't. And there is no type of timeframe that it has to be done within. But for myself going forward, it's going to be within 30 to 60 day range. And that is where Ashley is currently at with the complaints. So she is staying current also. So hopefully our office will be more current on all of that going forward. And then the other thing I wanted to mention that the commission decided at the last meeting, the beginning of June, was for education audits. I'm still performing the education audits. And if you were found short hours, you will be disciplined. You will have to make up the hours. So say you're 2 hours short. You're going to have to make up those 2 hours within 30 days, or you have to go on inactive status. And then you will have to pay $100 per hour you were short, up to $2,500. So that person would have to pay $200. If you're 15 hours short, you'll have to make up the 15 hours and have a $1,500 civil penalty. So that is kind of what the commission decided at the last meeting. We've had a few people over the last couple of years probably blatantly just didn't do their continuing education, and they're paying a $500 civil penalty where you're 1 hour short, you're paying a $500 civil penalty. So they wanted to kind of go away with that. And that's how they came up with the $100, basically $100 an hour type of thing. So, and then the other thing, as an education director, I do want to start auditing more courses and more of the schools. So that is a goal of mine in the future. But for right now, my goal is rewriting the rules. So I'll be doing that and then working on some more auditing type of things. But otherwise, any other questions or concerns I can address?
Hey, Renee, John Dunn with IAR Realty. I just have one question going back to all the reorganization and stuff being under the new department and all that. How does that, if anything, will because that's coming up real shortly here, how does that affect people that are applying to get their real estate license, like say a week from now or not? Is it going to be the same path? Nothing really, it's all behind the scenes. It's kind of changing things. Just want to get some
It's
clarity.
pretty much all behind the scenes. We're the ones being affected, not the public, not licensees. It's just basically how we're reorganizing within our bureau, I guess. But no, there won't be anything different. They are eventually within the year going to one database. So I have no idea how that'll look, but so that would mean one database for every type of license in the state of Iowa. And I don't know how they even predict that'll work, but we'll see.
Thank you.
Mm-hmm.
When you say they, Renee, who are you referring to?
The
Department of Management or Governor's
Governor
Office?
Reynolds people.
Okay, that's what I assumed.
All right, any further questions for Renee? Okay, well, again, thank you for your time, Renee. We appreciate you, and I'm sure you'll get some emails and questions after this for from attendees that maybe didn't want to be put in the spotlight. So
Yeah, and feel free to share my phone number and email. I'm here to answer any questions for you.
perfect. We will follow up with that. Thank you so much, Renee.
Thank you. Bye.
All right, so our second featured speaker today is Henry. He told me to just call him Henry. So Henry serves NAR as the MLS and Member Policy Manager. Prior to coming to NAR, Henry served as CEO of the Cape Cod and Islands Association of Realtors and Cape Cod and Islands Multiple Listing Service. Henry earned his Juris Doctor degree from Suffolk University Law School in 2014, passed the Massachusetts bar exam in 2014, and recently earned his Master of Science in Cybersecurity Policy and Governance from Boston College, Woods College, and Advancing Studies. Sorry, that was a long name. Henry has a passion for real estate association management and multiple listing service policies, which is, I didn't know there was such thing as a passion for that, but I'm so glad he has it. So Henry, what do you have for us?
Thanks so much today. Thanks so much for the opportunity to to speak for you. Today I'm going to be talking about clear cooperation, NAR's clear cooperation policy. And just for the record, I have the pleasure of working with Rodney Gancho, who is NAR's Director of Engagement. He's been involved with NAR for over 35 years. And Charlie Lee, who is General Counsel in the MLS realm, as well as Jason Sanchez, who's the new, he's been here for about 2 years as well for the MLS engagement. So I have the pleasure of working with all three folks, but I'm very happy to talk about NAR's clear cooperation policy. Did you, Amanda, are you going to show the slides and presentation?
Yeah, here you go.
Thank you. So I just want to just give you an overview of what I'm going to be talking about. I'm just going to give you an overview of the clear cooperation policy. I'm also going to address some corollary different just MLS policies in general. And I'm going to provide you with a list of resources and contact information. We have a policy line. We're answering questions from brokers all across the country all day long. So I'll give you that contact information if you have any specific questions and follow up. So next slide, please. So just to give you a history of the clear cooperation policy, NAR's MLS committee thoroughly vetted the whole concept of the clear cooperation policy, and it went to the NAR Board of Directors at the NXT meetings in 2019. It was passed and became effective on January 1st of 2020, and then required MLSs to adopt it by May 1st. The significant the background behind it is it really leverages the consumer benefits of an MLS to buyers and sellers and embraces fundamental principles of really broad marketing equals the greatest chance and best and higher offers. So in other words, if you provide it to all participants and subscribers, there's a high probability that the seller will and the listing broker will get, multiple offers and hopefully the best offers for that seller and in the specific market. And it reinforces fiduciary and ethical duties. I'm going to be talking about professional standards and ethical duties later on in this presentation. Next slide, please. So I think it's worthy. I know a lot of you have probably read the clear cooperation policy, but I'd like to really take this opportunity just to read it to you, just so you can, and then there's going to be an exception to this as well. I'd like to read these to you. So within one business day, and there's a lot of questions about one business day, but within one business day of marketing a property to the public, the listing broker must submit the listing to the MLS for cooperation with other MLS participants. Public marketing includes, but is not limited to, flyers displayed in windows, yard signs, digital marketing and public-facing websites, brokerage website displays, including IDX and VOW, digital communications marketing, including email blasts, multi-brokerage listing sharing networks, and applications available to the general public. Next slide, please. So there are, and so as I said, there's some pre-existing MLS policies I just wanted to review with you. Next slide, please. So under Section 1 of the Handbook of Multiple Listing Service Policies, they require for mandatory submissions of listings. So anything that is an exclusive listing agreement is subject under the real estate broker's license, and properties located within the specific MLS service area, and that the listing shall be delivered to the MLS within X hours after all necessary signatures of sellers have been obtained. So this is a matter of local discretion. Some MLSs, they have in the policy usually 48 hours, but some MLSs have shorter timeframes and policies, and that's up to the specific MLS in terms of what time frame you have to submit the listing. And that it also, this particular listing procedure applies to all MLSs where the broker participates. So for example, if Jane Doe was a broker in 2 MLSs and she takes a listing that it falls within the ambit or service area, she would put that listing in both MLSs in which she would be a participant. Next slide, please. So Section 1.3 basically accounts for the fact that there may be instances or iterations where a listing would be deemed as exempt. So for example, if the seller refuses to permit the listing to be disseminated by the service in the MLS, the participant can then take an office exclusive, and such the listing shall be filed with the service, the MLS, but not disseminated to participants. Filing of the listing should be accompanied by a certification signed by the seller. That's really important, and that she or he does not desire the listing to be disseminated by the service. For example, an example of a possible exempt listing might be where the seller might be sick and she or he does not want people going through the property. Sometimes celebrities, people who are private about, their specific property, or they may have other personal reasons why they don't want the listing disseminated to the membership, to the participants and subscribers. But this really emphasizes that last sentence. You need to have a thorough conversation with your seller about the benefits of MLS and why they may choose. It's up to the seller. So if the seller does want that excluded, the exempt listing would apply. Next slide, please. So I'm going to talk about other related issues here. Next slide. So what is a business day? So again, I mentioned earlier at the beginning of the presentation, we're taking calls from all across the country every day. And a lot of people call and say, gee, Henry, Rodney, Jason, what specifically is a business day? So according to the Clear Cooperation Policy, a business day excludes weekends, so Saturdays and Sundays and holidays, and it also includes recognized federal and state holidays. So any specific holidays to Iowa would be exempt from not being included in the business day. And this, the final bullet there is really a matter of local discretion about what the cutoff is. Some MLSs say 5 p.m. is closed of business day. Others say, later than 5 p.m., but the cutoff must be prior to 12 a.m. midnight. Next slide, please. And again, although this was all detailed in the actual Clear Cooperation Policy, a lot of people say, what exactly are examples of public marketing? And again, window displays, yard signs, digital marketing on public-facing websites, including brokerage websites such as IDX and VOW, which is part of the policy, digital communications marketing, email blasts, multi-brokerage listing share networks, if you participate in those, and other applications applicable to the general public, and including any promotion by the seller. We get a lot of questions on the policy line about what about Facebook? What about social media? Social media falls within the ambit of public marketing. So if someone is putting something on their Facebook page or whatever, that would fall within public marketing and trigger compliance to the Clear Cooperation Policy. Next slide, please. So we're just rationale and benefits of Clear Cooperation. So it really strengthens and reinforces the customer's benefits from broker cooperation, working with your broker so the broker can really maximize exposure of the listing for the benefit of clients, not only seller clients, but also buyer clients. It ensures that clients have an opportunity to benefit from the MLS's efficient marketplace exposure and optimal chance for the best deal. Again, if you only have it within your own company, you may have buyer clients that are interested in it, but giving that full exposure to all of the participants and subscribers in the MLS really provide maximum potential to get multiple offers and maybe even above asking price offers. So and it all depends on the market and conditions. It embraces the core tenets of MLS, including transparency, cooperation, and efficiency, and it also supports fair housing and equal opportunity to the property. For example, if you're only marketing, if you take an exclusive listing, it may limit people who might otherwise have opportunities to show interest in the property and make an offer on the property. So Clear Cooperation also supports fair housing and equal opportunity for all to the property. Next slide, please. Other considerations I want to talk about, next slide. So this is the importance of having a written listing agreement. A written listing agreement, and under property law, I'm not dispensing legal advice here, but under property law, you know, a lot of the benefits having contracts in writing. So the listing contract in writing forms a relationship, a written affirmative contract between the broker and the seller. And that particular contract authorizes the broker to act as the seller's agent and sets specific terms and conditions such as compensation. Depending on what your company model is, you may charge the seller X% or X dollars to market their properties. And also the benefits of a lot of the standard listing contracts, it provides remedies for possible breach if there is an issue between the seller and the client. So that's the importance of listing agreements. Next slide, please. Now there's risks, and especially legal risks, operating without a listing agreement. There's potential breach of state license laws. I had the pleasure of serving on the Massachusetts Board of Registration, the licensing board in Massachusetts, and we would get complaints from consumers that someone was selling their property or attempting to sell their property without having a listing contract. So that could be incongruous or inconsistent with Iowa state license laws. And basically without a writing, you may not have, you might be operating without legal authority to actually promote that and market that property, which creates liability, exposure to the broker for actions. And it fails to define your relationship. You know, for example, you know, if the seller, if you agree to just do something without having a listing contract, is your relationship exclusive? Is it more of an open listing because the seller might be entering into other verbal contracts or other verbal relationships with other brokers? And so then there's no guarantee without having a physical listing agreement in writing. There's uncertainty about payment and performance. Are you actually going to get paid once that property goes under contract? And again, it clarifies what's in the best interest of the client, which also typically is in the best interest of the broker. Next slide, please. So again, the legal risks in summary, there's a possible breach of agent duties, state laws and regulations, including fair housing, and even some allegations have been made, possible implications of antitrust without having a contract in writing. Next slide, please. Now, I mentioned earlier that there were some code of ethics implications here, and I know that we all, you know, voluntarily agree to subscribe to the code of ethics and follow the code of ethics, but I picked out 5 specific items that may be of interest I just wanted to review with you today. One, under Article 1, we're always putting our client's interests first above our own. We're agreeing to protect and promote the client's interests while treating all parties equally and fairly. Under Article 1, Standard Practice 12, we also advise the seller of policies regarding cooperation and compensation. So when you take a listing contract, I know everyone's doing this, but you know, you communicate with the seller, I'm going to be offering X apples to buyer agents or X apples to cooperating brokers. And that you agree to cooperate and make the property available for showing when it's in the seller's best interest. So if you don't take that exclusive exemption and you're actually marketing the property, you want to make sure under Article 3, Standard Practice 310, that you know you're not showing it to company X, but you are showing it to company Y and company Z. We always make full availability to show the property to all participants and subscribers within the MLS, and that we do not misrepresent availability to show the property. That's falls under Standard Practice 3.8. And finally, under Article 12, which also is very consistent with Iowa license law, is because Iowa license law, I took the initiative to just review the license law to be prepared for this presentation, and that pretty much every state license law has an advertising provision, which I know we're all doing, which is to be honest and truthful in communications and presenting a true picture in all of our advertising and other representations of the property, which aligns with Article 12. Can I have the next slide, please? So I'm going to go over 4 best practices here. The first one is, again, don't advertise the property without written consent of the seller. That is not only benefiting the seller, but is protecting yourself. Get the listing agreement that's legally compliant and fully executed. Again, You may have something in process and have met with the seller, gave them your presentation, but until both your signature and the seller's signature is on that contract, it's not fully executed. So make sure that it's fully legally compliant and fully executed. Next is be familiar with and follow your own state laws, regulations, and that, again, any MLS requirements and any triggers of you having to submit that listing to the MLS within that certain period of time, whatever your MLS or MLSs require. And then finally, is to make sure that the seller understands the pros and cons of the MLS and an exclusion. This is really significant. You know, there's a number of lawsuits that the National Association of REALTORS is engaging with, and Katie Johnson and Charlie Lee would tell you that it's really an opportunity to educate your sellers, let them know what the significant value and benefits of the MLS is, and if they are seeking an exclusion, that they understand what the limitations are there in terms of possibly, you know, if they choose not to put it in the MLS, what the possible limitations are in terms of the exposure. So again, next slide, please. Just it says explain. It's really worthy to know. Really, it's an opportunity to educate the seller. So the broker, as a broker, I know this is a broker meeting, and thank you for coming and participating. But we really have fiduciary duties to both the seller as well as to MLS, to your association and license law. So under your duties to the seller, you want to establish that agency relationship, always do what's in your client's best interest, whether it be the seller's best interest, and you provide reasonable care to your seller as well as due diligence. And then you balance that fiduciary duty and loyalty as well to the MLS and the association by adhering to and following MLS, any mandatory MLS policies, rules and regulations, the code of ethics, as we just talked about, professional standards, and any applicable license laws that Iowa has. So there's that symbiotic relationship where you're balancing and providing fiduciary duties to both the seller as well as to the MLS association and the law. Next slide, please. Now, this is something, I don't know if you want to take a screenshot of this. I have made, Amanda has my slides, they are available to you, but I'd like to just take a few minutes and talk about this. There's some phenomenal resources on NAR.Realtor that are available to you. There's a link to the Clear Cooperation Policy as well as Coming Soon. There's no National Association of Realtor policy on Coming Soon, so that's up to each individual MLSs. There are several articles that have been written that are also on NAR, NAR.Realtor. I highly recommend. Jason Sanchez does a phenomenal job putting together monthly MLS hours. He's the director of MLS engagement, and he did one specifically on Clear Cooperation. And I also acknowledge Charlie Lee, who puts together Windows of the Law videos. They're very succinct, on point, and have gems of information to protect you as a broker and to protect and something that you can also share with the agents in your firm. Again, these resources are freely available on NAR.Realtor, and you can always call the policy line. I have some contact information later on, but you can call there's a toll-free number to call the MLS policy line anytime, every single day. We have someone available in Omaha, Nebraska answering calls, and then they direct it to the policy team. So I just wanted to let you know and share these resources with you, because this is something where you can just go on point to NAR.Realtor and find really a lot of information that might be beneficial to yourself as brokers, as well as to those of your agents. Next slide, please. I just wanted to be succinct and be respectful of your time, but also open up for any questions that you may have. And I'm just going to hop to the next slide, because I wanted to also share with you, there's some contact information. If you want to directly reach out to myself or Rodney Gancho or Jason Sanchez, I have our email addresses and phone numbers here. But are there any questions that I may answer and assist you with today? And thank you so much for the opportunity to present.
We do have a question in the chat right now. It said, can you give examples of antitrust laws?
Okay, it would be price fixing. So for price fixing is a perfect example of antitrust laws. So like if you're taking if there's any collaboration or cooperation with other competitors in your market to say, okay, I'm gonna be, let's all agree to charge X percent when we're taking listings, or alternatively, let's all agree to only pay X, like Y percent to buyer agents or people serving in other capacities. Those types of things. I know this is typically on over in new member orientation. We used to do this all the time on Cape and the Islands, but those are things that brokers want to stay away from. You never communicate at all what your company is with other competitors. You never say, okay, I'm going to charge X percent, and so maybe we can all charge X percent, and that way we'll, those types of things run the risk of being offensive to the laws, and you want to avoid those types of things, specifically price fixing relative to antitrust laws. That's an excellent question. Thank you for raising that. Does that answer your question?
I think it was in the chat. So if
Okay,
it doesn't answer your question, type it back in.
Yeah.
Okay, and one question I had coming in was clear. It talks about public marketing of the property. And I think I already know the answer to this, but I would love for you to answer it. If someone calls you about a property, is it okay? The question was, is it okay for me to say, but I have something else coming up and here's what it is? Because is that considered public marketing if you're talking to an individual?
If you're talking about a specific property, so for example, you're taking a listing and you have not yet put it into the MLS. If you're talking about a specific property, that would fall within the ambit of compliance with clear cooperation. So if you're sharing it with someone outside of your company, so like if you're take a listing today on June 28th, and you're just about to put it into the MLS, and a consumer calls, or maybe a buyer affiliated with your firm calls and says, and you want to say, hey, listen, Thank you for working together with us. I actually have a property coming on board. We're going to put it in the MLS today. So once you talk about a specific property, then that would trigger your obligation to put it in to the MLS within 1 business day. That's that's really an on-point, excellent example, Krista. So I appreciate you're saying that. We get a lot of questions exactly like that on the policy line. So I think it's highly relevant, and I certainly appreciate that.
And to follow up on that question, what is considered talking about a specific property? So if someone had said, I have another property coming up, it's like 4 bedroom, 3 bathrooms, but doesn't talk about an address or any identifying, what I would consider identifying information. Can you kind of touch on what identifying information would be considered?
Yes, and I don't want to sound like an attorney because I'm not serving in an attorney role at any out, but it depends. And rather than just say that, let me walk you through the analysis. So like if you're on the phone with a client or a potential client and you say, I have a 4-bedroom unit coming available, and you don't really talk about the area, say, for example, like the Williamsburg section of the city, or you just say, we're having other 4-bedroom units coming on. If you're just saying that you have other 4-bedroom units coming on available, that would not necessarily trigger the clear cooperation policy. But if someone's, for example, is interested in a 4-bedroom, you say, listen, I have a 4-bedroom coming available on Main Street or on Oak Street, and that could potentially trigger clear cooperation. That would be an analysis that your local MLS compliance department would consider. So they typically would review these types of things. But the more broad it is, if you're just talking about 4 bedrooms in general, it likely would not necessarily trigger clear cooperation. But again, that's not for me to decide or IAR to decide. It's really up to your local MLS committee and or MLS compliance department that would do that. But I think just by virtue of the fact that you're holding this and educating people about clear cooperation, which is always beneficial, I think this will hopefully be helpful to everyone. Are there any other questions?
Okay, we had one more coming in. I'm just
Yes,
grilling
please.
you right now. So the question was, is clear cooperation considered a minimal standard? So can local boards or associations, can they put in more stringent guidelines than what clear cooperation determines?
Yeah, thank you for asking that question, because I think that's probably the most asked question that we get on the MLS policy line on a day-to-day basis. So the clear cooperation policy itself cannot be modified in its current form. So just say that, like the 1 business day specifically provision, but if you wanted to change your rules and regulations like section 1 and require participants to put their listing in like within 24 hours, as you know, which would be different than the 1 business day rule. A lot of MLSs are, I know, I hear from people all across the country, and some MLSs are considering more stringent rules where they would say that once you market the property, you have to put it within the MLS, say within 24 hours, which is a more narrow focus than just the 1 business day rule. So you would not actually do it. You would not modify the actual clear cooperation policy. Rather, you would, I appreciate your just making that just clear distinction. You would just modify like under section 1 of your rules that an additional provision. So that's a local MLS discretion, and you definitely have every right and option to do that if you and your committee and your board of directors are so inclined.
Okay, we have another question in the chat. It says, we have properties coming onto the MLS as pending. These are shown and offers accepted before the property is active on the MLS. How do we stop this?
And I think probably education. So if things are basically coming up as pending prior to entering them into the MLS, it suggests that it's either a pocket listing or an exclusive listing. And that's something that you would really want to really thoroughly, your compliance department at your local MLS would really consider that. This was an issue at the Cape Cod and Islands MLS that I used to manage, and we would basically reach out to we were kind of fine, and this is all individual policy, but we were kind of fine adverse. We would like to educate people. So we would call the people and say, listen, under clear cooperation or under our listing procedures, you have a duty and obligation to really offer that listing to everyone. If you haven't, you know, if it's already been, the offer has been put in, you have a listing agreement and you actually have it under contract before, then, you know, then we try to educate people. So that would be definitely something, an opportunity for your MLS committee to really consider in terms of how you can stop or really educate people so they know, you make sure that they are in full compliance with MLS rules and regulations.
Okay. Oh, go ahead, Byron. Nope, go please.
I just wanted clarification, Henry. You mentioned earlier a point about a person that belongs to multiple MLSs and that they're required to put that listing into each of the MLSs that they belong to. I live just outside of Omaha in Iowa, and so most of us belong to the Omaha, Nebraska MLS as well as the Council Bluffs, Iowa MLS. And the question, I got a call from a broker yesterday asking if the property was in Omaha, even though they belong to both MLSs, are they required to put that listing, that Omaha listing, in the Southwest Iowa MLS as well?
So you must know my colleague, Doug Rodhouse, who
I know Doug very well, yes.
He's one of my best friends. I grew up in association management with Doug.
Oh, okay. Yeah, you bet.
Absolutely phenomenal. So it really all depends. So if the Omaha MLS's jurisdiction includes the area of the specific listing, so I'm sure, because Omaha has a reasonably large MLS, if the Omaha MLS includes the address or city or town of where the listing is that you're taking, that you would include it in the MLS. If it's outside of the ambit or outside of the jurisdiction of the Omaha MLS, you would not have that obligation to put it in the Omaha MLS.
Really? Okay.
Yeah.
So now I belong to 3 MLSs. I belong to Omaha, the Council Bluffs right across the river, and then another one to the east of me. So if I'm hearing you right, if I list a Nebraska property, I'm only required to put it in the Omaha MLS and not the 2 MLSs in Iowa.
Well, if all 3 MLSs accept the listing or take that as part of their jurisdiction, a lot of MLSs have a pretty wide jurisdiction base, then you would in fact include it in all MLSs. And the other distinction that I want to make here is it's whether it's required to put it in or whether you want to put it in. If you want to submit it to all 3 MLSs to provide the maximum exposure, which likely you could argue would clearly be in the best interest of the seller, then you would want to put it in to all MLSs. I think you sound that you want to really do what's in the best interest of the seller, which would likely put it. The fact that you have our participants in multiple MLSs shows that you're really committed to really maximizing the exposure of the property to all and to do what's in the best interest of the seller. So you would likely want to put it in, and frankly should and probably would, but whether you're required to do it. So if you belong to an MLS that is not necessarily anywhere near the jurisdiction where you're taking the property, for example, then you may not have the affirmative obligation to put it in, but likely if the MLS will take it, you'd likely want to put it in there for the benefit of the seller.
Right.
And the buyers as well.
Right. Well, and that was kind of our policy. And I guess that was my question to this other broker. Why wouldn't you, if you're belonging to both, why wouldn't you expose it to as many people as you can? But they said, well, it's an Omaha listing. That's going to be the primary. We're not required to put it in the Southwest Iowa. And I guess what I'm getting to is who determines the jurisdiction then on adjoining territories like that? I would think they would have jurisdiction on each, but
I would agree with you. Like just to talk from my experience, typically the MLS I used to manage was Cape Cod and the islands, but we had a huge footprint where we would have cities and towns on the other side of the bridge within our MLS, and we would welcome as many listings as we could. And again, we had multiple people. We had a lot of participants who joined multiple MLSs like you have, Byron. And the fact that you are conducting business in multiple states and you have a pretty large footprint of your business and you're providing great services to your sellers by putting these listings in multiple MLSs, it would behoove, I would enthusiastically support what you're doing, and it would behoove you to put it in all of those policies, but in all of those listings. So as long as that MLS will accept the listing, then you would typically want to put that in there. If one of those MLSs might be a smaller MLS and they don't have the city and town populated within their choice of where to put it in. So I think the clear distinction would be, I'm just trying to be on point and answer your question, Byron. So if all three MLSs that you're a participant in basically will accept the listing and has the city or town and our state within the MLS, it likely would fall within the ambit of requiring to put it into all MLSs. So thank you for raising that question so I can make that clear distinction. But I really applaud the fact that you're doing that. I think that your business model, I think, is something that many people should emulate because you're giving it the broadest exposure for the benefit of both the seller as well as all of the clients within those jurisdictions.
okay, thank you.
Thank you.
Okay, Henry, we had a few more questions coming in as well.
Yeah.
So one of them is in regards to commercial or any type of commercial property. Does that fall under the clear cooperation guidelines?
That's another excellent question. So when the MLS committee and the MLS advisory board considered the clear cooperation policy, they did not contemplate or think, they thought about it, but they did not include commercial properties as part of CCP. So that CCP only aligns or relates to residential properties and not commercial properties. So the answer is no, commercial is not. It was considered, or at least the leadership on the MLS committee thought about that, but they felt that it would be specific to residential properties. That's another excellent question. Thank you for raising that.
One more, and this is the last one I have unless somebody sends me any more. One more is when it comes to, say, brokerage team meetings or office meetings, what is permitted as far as talking about listings that are coming up amongst the office? I know that it said, there was a slide that said like between offices, but there was a question
Right.
in office.
Right, that's, thank you for, I really appreciate you raising these points because these are really highly relevant and germane. So if you belong, if you belong to Krista Clark Realty and you have maybe 2 or 3 offices, you can discuss it within your company saying, okay, we have Sally Smith is taking a listing. We're hoping to get this written and under contract today or next Saturday or something like that. As long as it's within the ambit of your office, it does not trigger clear cooperation. But like, just say, for example, you're going out to lunch with a competitor and they say, oh, gee, Chris, did you know, I have a buyer client who's really looking for property within the area that you specialize, you know, or whether maybe, and if you were to voice that to a competitor outside of your company, that would trigger clear cooperation. So thanks for making that distinction. So if it's within your company, it's totally fine. But if you start sharing it outside of your company, or if your seller communicates it to their sphere of influence, that would trigger clear cooperation.
We have another question in the chat. Is multifamily commercial or residential, duplex, fourplex, or 24 unit or larger?
Yeah, I think anything, I think I can double check with this and get back to you, because I know that descriptions of, I know in different states have different requirements of what falls within commercial. For example, I know Massachusetts law, I think if it's greater than 4 units, it would be deemed a commercial property. And if it's, you know, greater than 4 units versus 4 units or less would be deemed residential. So I want to provide you accurate points that you can rely on. So what I'd like to do is bring that back, run this one by Charlie Lee in terms of, but again, commercial is not included in clear cooperation, but let me take that back to Charlie Lee. And if it's okay, I can get back to you or Amanda or both of you with that information if everyone's comfortable with that. I just want to provide on point, accurate information that you can rely on.
And
So
I can help with that. You're right. It's the same in Iowa. 1 to 4 family is residential.
Oh, excellent. Thank you.
5 or more units is considered commercial.
Thank you. So that's, thank you. Appreciate your expertise in answering that. Thank you. I wasn't sure of Iowa law. I know what Massachusetts law is, because I've been a licensed broker for years. I don't listen, sell, or compete with members now, but I've been a licensed broker since I've been 18. So I'm reasonably fluent in licensed law in Massachusetts, but not as much as I love Iowa and the Midwest. I'm not that familiar with that. So thank you for stepping up and helping me with that, Krista.
Absolutely. This has been great. Any further questions in the chat from the group, from the panelists, anything else to cover? Henry, I'm assuming you already shared your info. So Amanda will send that out, correct? All the links and the contact info for all the pertinent people that were on his slide. We'll send that out, correct?
Oh, yes, please freely share with everyone. And I'm really grateful and humbled for the opportunity to present to you and share this information. If I can ever be a resource, or anyone on the team, Rodney Gancho, Jason Sanchez, or Charlie Lee, we're here to help, and we're very, very happy to do so. And I'm very grateful for your time and attention today. And I hope I provide some helpful information for you and all the brokers in Iowa.
Absolutely. Thanks for taking the hot seat from me. I feel like I just totally grilled you for the past 30 minutes. So I appreciate your willingness to answer all the questions. Again, anybody else with any questions before we kind of just move on to wrapping it up? Amanda, oh, I saw you unmuted. Did you have something?
You've got a hand up here.
Oh, heck, yeah.
Make the panelists really quick. You just go ahead and set that.
1 second.
Maybe not.
No.
Okay.
We're good. Okay. All right. Well, I know that we always try to keep this as, succinct as possible and make sure that we are answering all your questions, but not wasting your time. So just another reminder that if there are any topics as brokers you would like to have covered in the next Zoom, we would love to hear from you on suggested topics. We want to make sure we're providing you with the information that you want and that is pertinent to your business. So other than that, with nothing else from the group, I guess that is it. We will call it a day. All right. Thanks, everybody. Have a good day.
Thanks, Henry.
Thank you. Thank you, Byron.